We're back for Your Ears Only. I'm David Alpern.
I'm Melissa Exelberth with a quote from the news. Examine the safety benefits of real-time tracking. That was the recommendation in a Malaysian government report on still missing Flight 370, which, more importantly, revealed a 17-minute delay in initial reports that the plane was missing, and hours before the nation's defense minister alerted the prime minister, who only then ordered a search for it. Now this.
I don't understand what the decision for you or against you when I write it is going to do to all kinds of other technologies. And I've read the briefs fairly carefully, and I'm still uncertain that I understand it well enough. That isn't your problem, but it might turn out to be.
Well, let me address,
It's not often you hear of a Supreme Court veteran confessing uncertainty or imperfect understanding, much less get a laugh for it. But Justice Stephen Breyer last week symbolized some recent problems for his fellow men and women in black as the High Court confronts high tech and how it meshes with traditional constitutional precepts. 2 weeks ago, it was a TV network case against the Aereo service that captures free over-the-air content, stores and forwards it to customers without paying copyright fees. Last week, it was a question over warrantless police searches through a person's cell phone, which these days may carry as much information as could be gotten tearing the same person's home apart.
To talk about specific issues, the court's comfort with and comprehension of high technology more generally, and some other recent cases for Your Ears Only, we're joined again by Marcia Coyle, Chief Washington Correspondent for the National Law Journal. Welcome back to the program.
Well, thanks a lot. I'm happy to be with you.
To what degree do the Aereo and cell phone cases reveal some difficulty for the court in deciding how bedrock constitutional principles and settled law can be applied to high tech?
Well, I think it was Justice Kennedy who said, and it may have been during the cell phone arguments, it's a new world, he said, and the fact that they're concerned about the impact of these cases down the road, I think, is not surprising because while it is a new world, they're dealing with old law. In the Aereo case, for example, they're dealing with the Federal Copyright Act of 1976. So, as you can imagine, a system like Aereo's was barely a twinkle in anybody's eye back in 1976, much less the eyes of Congress. And with the cell phone cases, too, they're dealing with the Fourth Amendment, which has been around a long time, and now they're being asked to apply it in a context that not only were the framers of the Fourth Amendment probably could never foresee, but in recent years, it's not the type of case that the justices have had to deal with. So it's really not surprising that they're concerned about the long-term impact, and also their comfort level varies by age of the justice.
Let's look at the Aereo case and the company's argument that it's created a complex system to do for customers long distance just what they have every right to do at home for themselves.
At the heart of this battle between Aereo and the broadcast networks is a provision in the federal copyright law that says copyright holders have the exclusive right to the public performance of their creations. And Aereo is claiming that it is not publicly performing anything here. It has private performances. Aereo has this very original system that relies on thousands of dime-sized individual antennas that are arranged on large antenna boards at its central facility. And when a subscriber for a fee to Aereo selects a television program, Aereo assigns temporarily an individual antenna to that user, tunes it to the appropriate channel to receive the program. The program can be saved to a large hard drive at Aereo's facility in a directory reserved just for the user. So Aereo says that when it sends the program back to the user, it's sending it to an individual user, and it's a private performance, not a public performance. And, of course, the networks are claiming this is hogwash. This is a gimmick Aereo's using, that you have companies like Netflix that are paying copyright fees to do basically what Aereo's doing. They say that Aereo is really the functional equivalent of cable TV.
Isn't the heart of the network's problem that over-the-air TV is free to the user and that recording devices, whether at home or at Aereo, permit consumers to skip the commercials that produce revenue for stations and networks? I mean, otherwise, Aereo could just tell the networks, well, you can include our subscriber base in your audience and sell that to your advertisers.
Right. Right now, Aereo's claiming that it is, when it sends the programs back to its subscribers, it's sending the whole thing, including the advertising. And so it's saying to the networks, you're really not losing anything here.
Let's turn to the argument over warrantless cell phone searches. Are they mostly looking for information on imminent threats to arresting officers or the public, or to prevent easy destruction of much evidence that might be important if it turns out there are grounds for charges?
That's right. In fact, you nailed it. Those are the two exceptions that the court has really created over the years for police officers immediately upon the arrest of someone. So you have now two defendants, one with a smartphone, the other with an old-fashioned flip phone, and they're claiming basically that the police had to have warrants here to search their phones because these phones were actually searched at the police station, and there was plenty of time for the police to get warrants, and there was no threat to the officer's safety, and there was no possibility of the destruction of evidence. On the other hand, the government's saying, it's not always at the police station. Officers are arresting people on the highway, on streets, and they have to make quick decisions. Today's smartphones, for example, the government argues, can be equipped with buttons that can immediately encrypt all of the information on the phones, and it now takes the FBI months to break through those encryptions, if ever. And also the phones can be used right away to trigger a bomb or to alert Confederates to the crime to either run for their lives or come and fight the police. So there is this tension here over really the capability more of the smartphone than the flip phone. On the other side, you have, as Justice Kagan pointed out during the arguments, people now carry their entire lives on their phone.
Marcia Coyle is chief Washington correspondent for the National Law Journal and a frequent guest on the PBS NewsHour.
Quote from the news, when times get tough, you help your neighbor. That was Pensacola, Florida pastor Craig Hinsman after rescuing at least 14 families from rooftops and balconies as devastating floods struck the Florida Panhandle and parts of Alabama. Severe weather continued throughout the South and Midwest, killing at least 38 people across 8 states.
Next, a gentleman sweeps up for your ears only.